Now I'm going to give you some very general information on Arizona community property laws. And the reason I said very general information is there's a lot of exceptions to the general rules that I'm sharing with you. It's very important, therefore, that you speak to a competent Arizona family law attorney about your specific situation to get advice as to what property may be your separate property and which property may be community property. So here we go. Generally, all the property owned by either spouse before marriage is his or her separate property. Also, all property received by either spouse, even during the marriage, as an inheritance or a gift, including a gift from the other spouse, is that spouse's sole and separate property. Now, generally, all property acquired by either spouse during the marriage is community property and would be equitably or typically equally divided in a divorce case. The sole and separate property of each spouse would be confirmed to them as their sole and separate property, not divided. The same general rules apply to debts as well. There are many exceptions, however, to these general principles. Just to name a few, a spouse may be deemed to have gifted his or her separate property to the community. They may be deemed to have commingled their separate property with community property, and the court is unable to distinguish, or we say trace, the separate property from the community property. To view our complete video series on Arizona community property laws, please sign up for our newsletter on our hildebrandlaw.com website. Alternatively, you can call us at 480-305-8300 or email us through our contact page on our Hildebrand Law Firm website.